The subcommittee will come to order. Good to have you all with us today. I'm sure the ranking member is on his way, but I don't want to penalize people who are properly present, so I want to go ahead and give my opening statement to get that beyond us. But it's good to have everybody with us, particularly our three panelists. Retrospective regulatory review is not a novel concept. There have been multiple good faith efforts to implement procedures and initiatives for retrospective reviews, but they have not produced sufficient results. This is partly due to the size and rapid growth of our regulatory system. It's also due to the complexity of our regulations and the incentives of regulatory agencies. That being said, several bills have been introduced on this topic, and I'm pleased to turn our attention to it today. Representative Quayle, a distinguished member of this panel, has, for example, introduced H.R. 3392, which, among other things, requires agencies to perform decennial reviews of existing major rules, including cost-benefit analysis, and to provide recommendations on improving these rules wherever warranted. Others, such as Representative Holgren and Representative Young, have also introduced bills on retrospective review. The theme throughout these proposals is consistent. Government should have some responsibility to audit and review its regulations. I believe this sentiment is supported by the prepared testimony from today's witnesses. Every member on this panel understands and appreciates the regulations are important for our safety and security, and that changing them outside of ordinary procedures for promulgating rules raises significant questions. At the same time, regulations impose a cumulative burden that is too high, and we should look for creative measures to reduce that burden. I'm very interested in learning today what proposals most merit our attention and support, and I'm also interested in know of any other suggestions from our witnesses that could assist our subcommittee as we pursue this matter more thoroughly. I understand that in addition to requiring agencies themselves to review their regulations, the creation of a legislative commission tasked for the sole purpose of reviewing existing regulations and reporting back to Congress may be a viable suggestion. If so, then what would be the mandate and parameters for such a commission, and what tools would be needed to make it effective? That being said, I hope today's hearing will be a productive first step, and I'm confident that it will be in making effective retroactive regulatory review a reality. And I look forward to the testimony from our witnesses. And if you all will bear with me, we're still waiting for a member from the Democratic side. I presume that someone is en route, so you all just stand easy for the moment, and we'll resume this ultimately, imminently, hopefully. While we're waiting, let me introduce our distinguished panelists, if I may. Randall Luter joined Resources for the Future in 2010, following a long and distinguished career as an economist featuring service in three different federal agencies under 4 presidents. Mr. Luter's past positions include Chief Economist and Deputy Commissioner for Policy at the U.S. Food and Drug Administration and Senior Economist at the Office of Information and Regulatory Affairs, Office of Management and Budget. His teaching experience includes serving as an adjunct professor of economics at American University and as an assistant professor of managerial economics and policy at the State University of New York in Buffalo. Mr. Luter earned his PhD and MA from Cornell University and his BA from the University of California at Berkeley. Dr. Luter, good to have you with us this morning as well. Dr. Michael Mandel is a chief economic strategist of the Progressive Policy Institute and the founder of Visible Economy, LLC, a New York-based news and education company. He is the author of many books and wrote a basic economics textbook for McGraw-Hill. Mr. Mandel also served as chief economist at Business Week magazine, where he was named one of the top 100 business journalists of the 20th century for his writings on innovation and growth. Mr. Mandel's work at the Progressive Policy Institute focuses on the impact of regulation on innovation. He currently is president of the South Mountain Economics, a consulting company, and a senior fellow at the University of Pennsylvania Wharton School, Mack Center for Technological Innovation. Mr. Mandel holds a PhD degree in economics from Harvard University. Dr. Mandel, good to have you with us as well. Professor Levin is a nationally recognized legal scholar who specializes in administrative law and related public law issues. He is the co-author of a casebook on administrative law and has published numerous articles and book chapters on administrative law topics. Mr. Levin previously served as Washington University Law School's Associate Dean and is currently a public member of the Administrative Conference of the United States. Prior to joining the faculty of Washington University in 1979, Mr. Levin worked as an associate in the Washington, D.C. office of Sutherland, Asbel, and Brennan. He clerked for Judge John C. Godbold at the U.S. Court of Appeals for the Fifth Circuit. Mr. Levin earned his J.D. degree from the University of Chicago and his B.A. magna cum laude from Yale University. As I said before, we are fortunate to have such a distinguished panel, and we will continue to stand easy till someone joins. A gentleman from California, from South Carolina is here.
Good morning, Mr. Chair.
A prominent golfer, I have been told. Good to have you, Mr. Scotty.
Delighted to be here.
With that in mind, we can commit. So, Dr. Luder, why don't you start us off? If you will, gentlemen, try to confine your comments to within the 5-minute rule if possible. You have an amber light that will appear after the green light vanishes. That amber light will alert you that you have about a minute to wrap up. Now, you won't be keel-hauled if you violate the 5-minute rule, but we do try to comply with the 5-minute rule. So, Dr. Luder, why don't you start us off?
Chairman Coble, members of the subcommittee, I'm pleased to be able to speak to you today about retrospective review and analysis of federal regulations. I'm Randall Lutter, visiting scholar at Resources for the Future. My testimony today is based partly on a report I recently authored for the Mercatus Center at George Mason University, which I submit for the record, and partly on my experience managing and evaluating federal regulatory programs to reduce risks. I've served in senior staff and executive positions at the Federal Office of Management and Budget, the Council of Economic Advisors, and the Food and Drug Administration. My work on different regulatory matters appears in a variety of scholarly journals, and my testimony represents exclusively my own views and not necessarily those of any organization. While the federal government offers substantial protections to Americans' health, safety, environment, and financial security, the specifics of federal regulation deeply frustrate many Americans as they try to read prescription drug labeling or mortgage disclosure forms, board airliners, or manage small businesses. Codified federal regulations today total more than 165,000 pages and have grown at an average annual rate of 2.8% per year since 1970. Concern over federal regulations has led President Obama to issue 3 executive orders on federal regulatory policy since January of last year. All 3 spell out policies on retrospective review, the reexamination of extant regulations to identify modifications, including possible elimination as warranted. My remarks today focus on such review and on the retrospective analysis that can inform such review. Today, I emphasize 2 specific questions. The appendix to my testimony provides supporting information and details. First question is how well recent regulatory review efforts have worked. 15 years ago, President Clinton's National Partnership for Reinventing Government under the leadership of Vice President Gore was successful in reducing the number of pages of regulations. The total number of pages in the Code of Federal Regulations fell by 7,000 from 1995 to 1997, leaving it about 14,800 pages below where it would have been if it had instead followed long-term trends. But a count of pages is not equivalent to regulatory burden or a measure of people's welfare. Moreover, in a later listing of accomplishments for its first 5 years, the National Partnership makes no mention of any specific reduction in regulatory burden. Were the economic effects of this simplification of rules nil, because the changes in rules were simply housekeeping steps, such as the elimination of unnecessary regulations governing buggy whips and horse-drawn carriages? Or were there instead genuine efficiency gains as the result of modification or elimination of regulations seen as inefficient with the benefit of hindsight? In fact, it's quite unclear what aggregate economic effects this reinvention initiative had, because there was no claim of aggregate effects, and I'm unaware of any estimate from an independent source. In the George W. Bush administration, the Federal Office of Management and Budget conducted different regulatory review efforts, including a major push to review existing regulation of the entire manufacturing sector that it began in 2004. I focused briefly on this effort, which OMB described in its 2008 report to Congress on federal regulations. Its effort began with 189 nominations that members of the public provided in response to a request in a 2004 draft report to Congress for suggestions for specific reforms to regulation, guidance documents, or paperwork requirements that would improve manufacturing regulations. OMB determined that 76 of the 189 nominations were priorities, and it found that 69 of the 76 reform items were complete as of January 2009. The items listed in that report are quite diverse and include many actions better characterized as administrative steps rather than modification or elimination of federal regulations. For example, the OMB report mentions 16 federal reports, at least 2 of which concluded that no change in existing rules was appropriate. The report also includes 4 guidance documents, which don't have the full force and effect of law. They also include actions such as an EPA determination, a response to a petition, a revised reporting policy, the development of an internal issue paper, and 1 action that appears to substantially precede the retrospective review process initiated in 2004, as well as a legislative action regarding taxation. At least 2 of these actions, however, EPA's spill prevention, control, and countermeasures rule and its hazardous waste rules to encourage recycling, likely offered significant savings. Since OMB didn't offer any aggregate estimates of the benefits and costs of these regulatory changes, however, there's little basis for an overall judgment. In the interest of time, let me offer a quick sum up, if I may. And a continuing challenge is efforts to measure the actual results of federal regulations. President Obama stated eloquently in an executive order in January of last year that the regulatory system must measure and seek to improve the actual results of regulatory requirements. This year, he reiterated that same phrase. In fact, it's very difficult to estimate the actual results, and regulatory agencies have taken only very limited steps in that regard. So let me stop here and say that I look forward to this opportunity to testify. I'm grateful for it, and I look forward to your questions.
Thank you, Dr. Luter. Dr. Bandel.
Mr. Chairman, members of the subcommittee, thanks very much for the opportunity to address the issues with the retrospective regulatory review and alternative mechanisms for reducing the burden of regulation without losing its benefits. Much of my testimony is drawn from a policy brief published in February of 2011 by the Progressive Policy Institute, where I'm Chief Economic Strategist. I'm also affiliated with the Max Center for Technological Innovation at Wharton as a Senior Fellow. One of my main concerns as an economist is the link between innovation and regulation. Innovation is the key force propelling growth and creating jobs. On the other hand, regulation is essential for making our economy work smoothly. Unfortunately, if the regulatory burden is too heavy, it can tend to suppress the innovation and entrepreneurial energy that we need. So if we care about the long-term performance and competitiveness of the American economy, we have to focus on periodically lightening the regulatory load. This is not a new idea, as Dr. Lutter describes. It's not even terribly controversial. Reaching back to Jimmy Carter, every president, Democrat and Republican, has instructed his agencies to reconsider and review existing regulations. Yet, without exception, all of these attempts at retrospective review seem to have produced considerably less than the desired result. One might almost say they have failed. The question is, why is retrospective review so hard to do effectively? One issue is foot dragging by agencies, but that isn't the whole story. First, the retrospective review process consists of analyzing the costs and benefits of each regulation individually. The problem is that it's possible for every individual regulation to pass a cost-benefit test, while the total accumulation of regulations still creates a heavy burden on Americans. The number of regulations matter, even if individually all are worthwhile. I call this the pebble in the stream effect. Throw one pebble in the stream, nothing happens. Throw 2 pebbles in the stream, nothing happens. Throw 100 pebbles in a stream, and you've dammed up the stream. Which pebble did the damage? It's not any single pebble, it's the accumulation. The other issue is the very structure of the regulatory process makes it more expensive and difficult to undo regulations than to create them in the first place. When the original reg is put in place, the agency can use whatever evidence is available. By contrast, after the regulation has been in place for a while, the agency has to do a cost-benefit analysis using real data on actual outcomes and costs, which is expensive and difficult to collect. So what we need is a process that allows us to tackle the accumulation of regulation without having to fight over each one individually. What PPI has proposed is an independent regulatory improvement commission, modeled somewhat along the successful process set up for the Base Realignment and Closure Commission, or BRAC. The Regulatory Improvement Commission would be given the task of coming up each year with a package of 10 to 20 regulations to undo, rewrite, or otherwise improve. They can be small regs or large ones. The package is sent to Congress for an up or down vote, and then if passed, sent to the President for his signature. What are the benefits of the Regulatory Improvement Commission over a retrospective review? First, it would get us away from agencies reviewing their own regulation. The Commission would draw on expertise from different agencies, but it would be able to make an independent decision. Second, if the experience with BRAC is any guide, voting on a package of regulatory reforms would be easier than hand-to-hand fights over individual regs. Third, and perhaps most important, having Congress vote on the package of reforms legally allows us to short-circuit the cumbersome regulatory review process. The Regulatory Improvement Commission would hold hearings, but because the package of reforms would need the approval of Congress, the hearings wouldn't have to be arduous compared to the process that an agency would have to follow by itself. The bottom line is that the Regulatory Improvement Commission needs to combine efforts of both the legislative and executive branches to be effective. The executive branch by itself cannot get a grip on the problem. That's why retrospective review doesn't work no matter who the president is. I should note that the February 2011 policy brief lays out some more details about how the Regulatory Improvement Commission could be structured. For example, the scope of the commission could be structured to stay away from environmental regulations or expanded to encompass agencies such as the FCC. The commission could be made temporary like the BRAC Commission so that it regularly has to be reauthorized. The commission could set up a website where businesses and individuals could submit suggestions for which regulations to undo or change. In truth, there's a lot of different ways to make a Regulatory Improvement Commission work. The key is to set up a mechanism which offers a systematic and objective process for identifying a package of regulations to be undone or fixed, while acknowledging that Congress has to be an essential part of the process. Thank you.
Thank you, Dr. Mondale. Professor Levin?
Thank you, Mr. Chairman and members of the subcommittee. As the chairman mentioned, I am a scholar who specializes in the field of administrative law, and I think you would find a broad agreement among students of my field that agencies don't do as much re-examination of their existing rules as they should. In any large regulatory program, there are going to be some rules that have outlived their usefulness or need updating, or perhaps can now be seen as having been mistakenly drafted from the beginning. So the question is what steps might be taken to identify those rules and how to go about fixing them. The administration has devised an elaborate look-back program, and the subcommittee should evaluate its track record, but I'm prepared to assume for purposes of today's discussion that Congress will take a serious look at establishing a program of retrospective reviews on its own. The other panelists today have some interesting ideas for setting up external bodies to manage the retrospective review or look-back process, but at least for purposes of comparison, I intend to explore how Congress might structure a mandate for retrospective review to be administered by agencies themselves, which is the more common pattern and possibly the most workable one. In my statement, I draw on recommendations issued by the American Bar Association and the Administrative Conference of the United States on the very subject of retrospective reviews. Those are both organizations that I've worked with for years, although I'm not speaking for either of them today. Specifically in this discussion, I'll emphasize 4 themes that I believe the subcommittee should take into account as it considers possible legislation on retrospective review. And I call these themes selectivity, affordability, flexibility, and even-handedness. As to selectivity, I think priority setting is essential to an effective scheme. If you direct an agency to review all of its rules, as sometimes has been done in the past, they will do a superficial job on them. So if you want a rigorous examination of a rule's effects, That level of effort should be targeted at particular rules in a well-considered fashion, and the agencies will need discretion to do that. But when I say discretion, I don't mean to imply that they should make their selection of rules to be reviewed in isolation from the rest of the world. I think you should have opportunities for input by OIRA, by the White House, by the relevant oversight committees of Congress, and from the public. And these days, of course, the internet makes opportunities for the public to participate easier than it ever has been in the past. The second criterion I offer is affordability, by which I simply mean that rigorous research into the effectiveness of a rule will take real resources. And if Congress wants the agency or anybody else to do it, it will need to provide funding for it. And I know that's not a small consideration these days. Agencies are already, in my opinion, seriously constrained by tight budgets in carrying out tasks that Congress has assigned to them. But these days, many members are have instituted tight curtailment on discretionary spending, and there are proposals to constrain it even more. And there's a tension between that impulse and the goal of promoting careful analysis that hasn't been done in the past. My third criterion is flexibility. By that I mean the legislation should not be too detailed about how the reviews are to be conducted, because various programs have different structures and different needs. Specifically, the ABA resolution that I mentioned identifies as possible alternative approaches multi-agency reviews, reviews by broad categories of rules or by subjects or by impact on specific groups like small business or state and local governments, or cleanup reviews to get rid of entirely obsolete rules. I think a statute that governs retrospective reviews might provide a menu of approaches for an agency to follow, but it should not try to make one size fit all. My fourth criterion, fourth and last, is what I call even-handedness. Some rules become obsolete by being too restrictive, and others become obsolete by being too weak. And a balanced look-back process should facilitate an agency's capacity to repair either type of problem. In my statement, I use the example of pollution standards that EPA issues under a mandate to apply the best technology available. Well, technology evolves, but the agency often doesn't get around to strengthening its rules to bring them into compliance with the statute. Now, of course, there are going to be disagreements in this body and elsewhere about how much the problem of overregulation compares with the problem of underregulation. But if you want to establish permanent legislation along the lines of the Administrative Procedure Act, it should be politically neutral, and you then leave it to the political process to determine at any particular time what rules are causing the greatest problem. With that, I'll conclude my oral statement, and I'll be happy to respond to any questions you may have. Thank you again for letting me testify.
Thank you, Professor. Thanks to each of you for your testimony. We've been joined by the distinguished gentleman from Arizona, Mr. Franks, and the distinguished gentleman from North Carolina, Mr. Watt. And gentlemen, we try to apply the 5-minute rule to ourselves as well, so let me get with it. Dr. Luter, to what degree have past regulatory review efforts produced few results because the Congress and the White House have lacked sufficient leverage to force more effective reviews?
The reviews have been modest in terms of their accomplishments. So I don't mean to leave the impression that the accomplishments are nil, the ones that have been conducted to date, either in recent administrations. But if one looks at the broad scope, the pebbles in the river, a metaphor of the other speaker, and the full extent of accomplishments of these reviews, one is left with the conclusion that there's a few rules alone which are changed, and the vast majority are left unchanged in broad scope. With respect to your question on the congressional authority, I think the Reg Flex Act already has a provision, if I recall, it's Section 306, which directs agencies to conduct which requires agencies to conduct a regulatory review on a prescribed basis. This act is widely seen as not especially effective. It's adhered to in the breach, and there's a collection of GAO reports which essentially acknowledge that. I think the challenge here is between a balance between the agencies which have substantial expertise in the design and the management of their regular programs, and the need to get some independent, outside the agency stimulus for the change. And the reason for the independence is exactly the difficulty associated with self-review. People are reluctant to review their own work in an effective way.
Thank you, Doctor. Dr. Mandel, would it be best to give the Commission a mandate to focus on specific sectors? For example, retrospective review of manufacturing regs in year 1, environmental regs in year 2, communication regs in year 3, et cetera.
That's an excellent point. I think that at least the first year or the first couple of years, it should have a limited mandate so that people can get used to sort of how it works. In particular, and this may sort of disappoint some people, I think that in the first couple of years, it should stay away from some sort of really controversial topics like environment, so that people can get used to this idea that we can undo regs in this way, and then over time, as people get used to it, the mandate can be expanded.
I got you. Thank you, sir. Professor Levin, if Congress were to establish a regulatory review commission, would it be best to frame the commission with a short-term mandate? For example, say, period of 1 to 5 years.
My concern about a commission more broadly would be that you have a group of outsiders who don't have the agency's experience in administering a program as a whole. And so if they identify particular rules to target, they may make the wrong choices. And if, as has been proposed, they are able to put forward their proposal without a record or an extensive record, the kind that an agency needs to compile, without a reasoned explanation of why they chose it, they may not make good choices. And if it's really true that all the rules are interconnected, they may, by picking out individual rules, cause disruption to the overall scheme. So my concern is that an agency that the commission might not be a reliable instrument, and if it gives a short term, as you describe, it doesn't even have the chance to develop expertise over time to alleviate that problem.
Would former heads of agencies be desirable for membership on such a commission?
Oh, I definitely think if you have such a commission, former heads of agencies would be good candidates for appointment, but that doesn't get to the ultimate problem, that they aren't responsible for running the show at the moment.
Thank you, Professor. I see my amber lights on. I'll yield to Mr. Watt, the gentleman from North Carolina.
Thank you, Mr. Chairman. Thank you for having the hearing. Dr. Luter, I believe you've testified before the Energy and Commerce Committee or one of their subcommittees previously, and in that testimony you made the following statement, quote, "Perhaps surprisingly, there's been relatively little scholarly empirical economic research about the effects of environmental regulations on employment," close quote. And then you cited 2 studies which had conflicting results on this impact. I'm wondering, since you have testified there, have there been any additional empirical studies confirming that regulations adversely impact job creation?
Thank you for the question. I haven't done a survey since that testimony, so I'm unaware of any specific new work on that point. I know that people are researching it actively, but I don't know if they have any conclusions to report.
Dr. Levin, are you aware of any research in this area, either ongoing or completed?
Right. My understanding of the research is that the volume of regulations has a fairly weak relationship to employment. I think these days the main concern about lack of employment is lack of demand. So I don't think the connection with regulations is a strong one, and that's only looking at the cost side. regulations also have benefits which can improve the economic climate.
Now, you alluded to some of those things in your evaluative 4 criteria. Give me those 4. Just click them off for me again quickly if you can.
Yes, I mentioned selectivity of which rules to review, affordability of the process, flexibility in designing it, and even-handedness in choosing which ones to review. And as to the last point, my point is that sometimes a rule is out of date because it needs to be strengthened, other times because it needs to be weakened or repealed.
So let's focus a little bit on the selectivity part of this, and I guess I would ask all of the panelists, in assessing a regulation, should avoiding red tape be prioritized over saving lives, or should job creation be prioritized over saving lives? What would your assessment on that? If a regulation saved lives and it was intended to do that, should we be encouraging a reprioritization away from saving lives to either avoid red tape or to promote job creation? Anybody got any opinions about that? Dr. Mandel?
I think that it's quite possible for any particular regulation that the balance would be in favor of saving lives. But I also think that we have a problem, which is that we could keep accumulating regulations like that, where each individual one makes sense, but then taken together, it's too much of a weight on the economy.
So it'd be a fair thing to assess all of those rather than
assess all of it. But actually, let me give you another metaphor. I think about regulations in some sense as barnacles on the bottom of a ship. Okay, you just kind of have to start scraping them off at some point. Mm-hmm. And if we go looking for bad regulations, it's like looking for the worst barnacle. Okay. It's not something that doesn't, it's the totality of it that we have to worry about.
So I assume you agree with Dr. Levin that any kind of retrospective review should be even-handed.
Yeah. When we talk about a regulatory improvement commission, we're very careful. It's not deregulation. That the commission would be charged with both undoing regulation but also potentially improving them.
Right.
And one of the reasons why we think of that Congress needs to be involved in voting this up or down is because, the fact of the matter is, I went to put it exactly the same way the professor did, but in fact, once you start looking at regulations, a package that would be acceptable politically might have to include some tightening as well as some loosening.
And I think my time is up, but if I can squeeze in one more question, Mr. Chairman. I assume just like life-saving regulations that are designed to save lives, some regulations can actually encourage innovation too. Hasn't that been your experience?
That's right.
Can you give us a couple of examples of that?
Potentially some regulations can encourage innovation, though actually I generally think that if we're talking about genuine innovation, that the best thing to do is to sort of have less regulation rather than more.
Give us an example of where a regulation has actually incentivized innovation.
At this point, I mean, we're very concerned about innovation. We're very concerned about the impact of people, but in general, government is not the best.
You're not answering my question.
No, because
if you're aware of situations where innovation has actually been promoted by regulation, that's the question I'm asking. Are there specific examples? It's not a catch-22 yet.
No, it's not a. And I'm trying to answer the question genuinely here. Is that I'm really not aware of regulation.
Okay. Well, that's a fair answer, and I can't push you, but I'm no reason to waste time answering questions other than that, which is.
Gentleman's time's expired.
I yield back. Thank you.
The distinguished gentleman from South Carolina is recognized.
I thank the gentleman from North Carolina, the chairman, the president, Mr. Chairman, and the State of the Union said we should have no more rules or regulations than would be necessary for the health, safety, and welfare of the American people. Can either of you three name some major rules and regulations that would violate the president's standard, in hopes of maybe giving some of these agencies a jump start on their retrospective review? Not all at once.
To take a shot at this, and I mean, I've been asked this question many times before, okay, and my response is always the same, that the problem is that the accumulation of regulations rather than any particular bad one. And so I basically refused to sort of identify one. I said, look, we've got too many regulations, but to sort of say any particular one needs to be removed, it actually doesn't reflect what the truth is. If we go looking for bad regulations, sort of the ones that are job killing, okay, we're not going to find them.
Well, again, and I may have misapprehended what the president was saying. I thought he said he had identified 500 himself. And I figure with all the various restraints he has on his time, no offense to the three of you, but you are all experts in the field, that you would be able to come up with a whole lot more than 500 given the amount of time you're able to dedicate to the topic. I don't think, in the interest of time, you can list 500. I think the chairman would gavel me down, but you can give me a couple, can't you?
My answer would be that it's probably not a matter of saying that certain regulations should simply cease to exist. I think the president's point is that in drafting particular regulations, even ones we need, you should structure it in such a way that it does not go further than is necessary to promote its objectives. And so I don't think of it as an either-or question, and I suspect he did not either.
Am I pronouncing your name correctly, Dr. Lutter? Is that correct?
Yes, sir.
Maybe you can help me. The president says he can come up with 500. Even Cass Sunstein, the noted professor and regulatory expert, says there's some. Humor me. Give me a couple.
Well, I'll go out on a limb. I think, first of all, there's a clarification about what we mean by regulation. And the language I like to use is regulatory program versus rules. And the way that many of the specialists use rule or regulation is a particular action as published in the Federal Register, which is a specific rule. But that's not always the common usage. I'm going to talk about regulatory programs rather than specific rules. At the Food and Drug Administration, many people believe that the regulations to reduce the risk of spread of bovine spongiform encephalopathy, commonly called mad cow, are addressed at something that is really, really small risk. And that's not to say zero risk. It's simply a risk which is widely seen by specialists as very, very small. So one can't say that this has no effect on health or safety. It's simply that the effect would be small if balanced against the cost of that regulation, including the cost of administering it, which is borne by the federal purse. Secondly, there's been a collection of estimates over many years, including those funded by the EPA in the late 1990s, evaluating the Superfund program as a whole. And that's not to say any specific rule associated with the Superfund program, but instead its effect on the whole. And the valuation is usually expressed in terms of dollars of total compliance cost relative to cancer case averted. And similar work that's more up to date on that program by Michael Greenstone, which looking at other metrics other than cancer cases averted, also appears to suggest that it's relatively high cost per unit health improvement. Among specialists who work on environmental actions, the Resource Conservation and Recovery Act has a collection of regulations which are often thought of as a relatively high cost per unit health improvement or per unit gain in environmental protection. So I would nominate these three as not necessarily as ones to be revoked, but as ones that would merit the consideration of the commission that's been discussed earlier today.
I'm out of time, but if the chairman would allow me to ask one more question, I would be forever grateful.
Without objection.
Thank you, Mr. Chairman. Can you each give us briefly your perspective on the REINS Act, which passed the House, and concomitantly, what role, if any, you would give the judiciary with respect to review of our regulatory apparatus? Which role the judiciary should have that it doesn't currently have? So the REINS Act and judicial review.
I think the REINS Act is one of the worst ideas I've ever heard of, because I think it would lead to gridlock not only in the enactment of laws, but also in the implementation of laws. It would mean that a major rule couldn't be implemented unless you had the concurrence of all the branches of government, and that is frequently not going to be possible. And so I would stay away from it. As far as the judiciary's role is concerned, I think it plays a very important role today in reviewing rules, basically a sound rule, and so I think it works in a way probably more or less as it should, and so I would not make major changes in it.
I'm going to pass on this question. Thank you.
I've not researched the REINS Act, so I think I lack the expertise to comment on it.
How about judicial review? Do you have expertise to comment on that? Additional judicial review, retrospective judicial review.
I'm much more comfortable with the idea of a retrospective review done by a commission, which is the joint product of Congress and the administration. Okay, because I think ultimately, regulations are the product of the public will. Okay, and the undoing of regulations or the improvement should be viewed by the bodies, by the branches of government, as the expression of public will as well.
Could I get?
Gentleman's time has expired.
Thank you, Mr. Chairman.
Thank you. Dr. Luder, I mispronounced your surname earlier, and I apologize for that. The distinguished gentleman from Georgia.
Yes.
5 minutes.
Thank you, Mr. Chairman. Professor Levin, would you say what you were getting ready to say in response to that last comment that Dr. Mandel posed?
Oh, I didn't mean to cut you off, Professor. You were.
Well, if it doesn't apply to my time, if he could answer.
Just now, I was going to speak to the issue of judicial review in relation to retrospective review, if that's what you have in mind. What I was going to say is that anytime somebody thinks that a rule is out of date, an interest group, a person, can file a petition to rescind it with the agency. The agency needs to respond to it, and if you're not satisfied with the response, you can go to court and challenge this decision as an arbitrary decision. And so we do have a mechanism in place by which a rule that seems obsolete can be challenged, and the agency can be forced to come to terms with it.
So there's no need to muck up the process, bringing politics into the fray in terms of the utility of a particular rule is concerned.
So I don't think you need another layer of review with respect to the retrospective review process itself.
All right, thank you. I would like to know, Dr. Mandel and Dr. Luder, do you think that American businesses and the U.S. economy would be better off without the Clean Air Act and its associated regulations? You think we'd be better off without it?
You want to go?
Well, nobody wants to answer the question.
The Clean Air Act is a very important act. There has been actually a retrospective study, which you may be aware of, sir, under Section 812 of the Clean Air Act, evaluating the costs and the benefits of the act.
Do you think that it is better that we would not have a Clean Air Act? Is it your opinion that we shouldn't even have that act? Yes or no?
We're better off with the act than with no act, sir.
What about the Clean Water Act? You think we'd be better off without that?
I haven't studied that in enough detail to know, sir.
What do you think about it, Dr. Mandel? Now, that's a very important act that, it's one of the things that people most in industry, one of the acts that people most challenge. And you're not familiar with that act.
My training and my experience, sir, is always to focus on certain provisions of certain rules or certain acts.
All right,
and in that sense, to evaluate it in its whole is really difficult because one has to ask what is the alternative that would
And I
exist in the
realize
absence
that
of
you
it.
are an economist and not a lawyer, so please forgive me. Thank you. Dr. Mandel,
I think we're better off with the Clean Air Act.
what about the Clean Water Act?
I think we're better off with the Clean Water Act. Now, we could...
Now, what acts
we could
would
sit
we
here-
better,
we could-
what acts can you cite right now that we would be better off without in their entirety?
Now, remember,
Well, no,
what I
no, no,
started
no,
off by saying was that we could throw pebbles in the stream and it wouldn't dam up the
All right,
stream.
okay.
So I'm worried about the totality.
Well, let's talk about the pebble in the stream effect. Throwing one pebble in to the stream doesn't do anything. 2 is okay. 3 is okay. 100 dams up the stream. Which pebble did the damage?
Right?
And is that important? Is it
and
important that we discover
It's a
that?
hard question. And so at that point...
And it's a hard question to answer. Is it better for the regulatory rulemaking authorities and the affected industries to have dialogue and try to reform and refashion the rules in that way, or is it better to just throw it into the legislative branch and let us muck it up and bog it down in politics and Koch brothers money, soft money, hard money, whatever money? Do you think it's better to just put it into that system that we're dealing with now?
My response is
Yes or no?
The answer is I think it's that retrospective review hasn't worked. Okay, that it sounds good, but it hasn't worked, and so therefore we're looking for an alternative to that.
All right, Professor Levin, if you would.
Right. So one concern I would have is if you give an independent body jurisdiction over 15 different dams, they may tinker with each of them and remove parts of the dam that may not be effective in terms of the overall purpose of the dam. So I think you do need the specialized perspective of an agency with respect to each one. Incidentally, I support the Clean Air Act and Clean Water Act.
All right, well, I kind of assumed that you did. I do too, if anybody was curious about it. Do the federal agencies...
Would the gentleman like an extra 30 seconds?
I would. Well, a minute if you could spare it.
Well, I'd given you a minute before I asked you if you wanted 30 more seconds, but how long would the gentleman from Georgia, the distinguished gentleman?
I just have one more question.
Absolutely,
Thank
without objection.
Thank you, Mr. Chairman. Do the federal agencies, particularly in this era of slash and burn budget cutting, have the resources that they need to undertake their regulatory reviews, their retrospective regulatory reviews?
Absolutely not. And that's partly why I'd like to see it move to an independent commission, because I don't want the agencies to have to use their scarce dollars to do the retrospective reviews.
That sounds like a recipe for efficiency and perhaps even just wholesale review. Not careful review, but wholesale politically charged review. Dr. Luda?
May I also answer your question? I think the answer is no, and I think that's one of the challenges why the agencies as a group have done so little careful retrospective analysis of the existing rules.
So you disagree with the Republican slash and burn ethic of the 112th Congress? Is that a fact?
I'm not sure what that ethic is, sir.
Well, it's to cut regulations and make
The,
it easy for business.
The gentleman is now into his third minute of what in soccer they call extra time, I believe. So with that,
Well, could he just answer that question?
well, you keep asking new questions after the last one, as any good lawyer would, and you are and were. But if Dr. Lutter, if you would like to briefly, I emphasize for effect and pause briefly, answer that question, you may.
And thank you, Mr. Chairman.
Yes, sir.
May I ask to have the question repeated?
I'm a little too old for that now, Dr. Luter. We can, with that, Mr. Chairman, I'll yield back.
I thank the gentleman from Georgia. And with that, on behalf of Chairman Coble and all of us on the committee, we want to thank our witnesses for their testimony today, for their collegiality and comedy, not just with the members of the panel, members of the committee, but also with one another. Without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witnesses to respond as promptly as they can so their answers may be made part of the record. Without objection, all members will have 5 legislative days to submit any additional materials for inclusion of the record. With that, again, thank all of our witnesses, and this hearing is adjourned.